Hi everyone, I am Judge Anarica Castillo Reyes, and this is Property and Land Registration Laws. Property is Book 2 of the Civil Code, and we will basically be dealing with basic property and land registration laws, Chapter 1 of which deals with immovable and movable properties. So let us begin our journey in property law. Um, Article 414 of the new Civil Code classifies properties according to their nature. And the classification is immovable as well as movable properties. If we will read Article 414, it states that all things which are or may be the object of appropriation are considered either as immovable or movable properties. So you might ask, what is property? So that is primarily the basic question that we should answer in dealing with properties. But the Civil Code did not define what is property. Several commentators have distinguished between things as opposed to property. Thing is a broader concept because it includes those which cannot be the object of appropriation, although they are capable of satisfying human needs. Example of which are the ocean, the open sea, the Earth's atmosphere, the aurora borealis. So they provide utility. They are capable of satisfying human needs, but they are not capable of being appropriated. As you can see, the capability of appropriation is one of the essential elements for a thing to be considered as property. If it is not capable of being appropriated, then it can be considered as a thing, but it cannot be considered as property because they lack individuality. So if you cannot appropriate it or uh, exclusively to yourself, then it is only a thing, but it cannot be considered as a property. Now we go to the characteristics of property. What are the basic characteristics of property? We have three. First, it is the capacity to satisfy a human want or a need. Because if something does not satisfy human want or human need, then there is no desire for man to appropriate it or to get it because it does not provide any service or utility. So it is necessary for a thing to be considered as property for it to be of service or of utility to people. Okay. Now, the second characteristic of property is the capacity of having individual existence. So, individual existence is needed for the purpose of appropriation because a thing which does not have individual existence is not capable of being exclusively appropriated by any person. So, like, for example, the Earth's atmosphere, okay, or the ocean, the open seas. So because of its broadness, it cannot be the subject of exclusive appropriation. Okay, and then the third requirement for a thing to be considered as property is the capability of being appropriated or of being enjoyed or possessed by people. So the belongingness or the capability of being owned is something that a property should have. So for a thing to be considered as property, it needs to be exclusively appropriated or possessed. If it cannot be exclusively appropriated or possessed, then it is a thing, but it cannot be considered as property. So all those three characteristics or attributes must be present for a thing to be considered as property. Okay. Now, since Article 414 gives the basic classification of property according to its nature. Okay? What then is immovable property? Again, the Civil Code did not provide any exact definition of an immovable property, but it defined immovable property by enumerating the properties which are considered as real or immovable properties. So if you can look at your screen, you will see the 10 properties which are included in the enumeration of immovable properties. This enumeration is very important because when we go to personal properties, we will look again at Article 415 because we have to consult Article 415 in determining whether a certain property is a personal or a movable property. Because all those which are not included in the definition under Article 415 are considered as movable property. Okay? So let us go to each item specified under Article 415 as immovable or real properties. Okay, first, we have those which are immovable by nature, such as lands, buildings, roads, and constructions of all kinds adhered to the soil. Okay, they are immovable by nature because they cannot be transferred from one place to another. Land is the basic immovable. Of course, you cannot transfer land because they are fixed. Okay, it is the classic definition of an immovable. Buildings because they are attached or adhered to the land, as well as roads and constructions which are attached or adhered to the soil to which they are fixed, can also not be moved from place to place. So that is the reason why they are called immovable by nature or the traditional immovable. However, if the building is demolished or severed from the soil, the building materials become personal property. Once they are removed, they become personal property. A makeshift house, for example, which is not permanently adhered to the soil, the traditional bahay kubo, which you see being sold in the roads, they are not considered as immovable by nature because they are not adhered to the soil. However, jurisprudence teaches us that even if a land, building, and all kinds of constructions which are adhered to the soil, although they are considered as immovable by nature, the parties can stipulate and consider that property as a personal property, and they are bound by the said contract or stipulation under the principle of estoppel. So I have classified, for purposes of easy recall, I have classified the immovable properties as follows. We have those which are immovable by nature, which I have previously discussed, such as lands, buildings, roads, and constructions of all kinds adhered to the soil. As I have told you, they are immovable by nature because they literally cannot be moved from one place to another. Okay, and then we have those which are immovable by attachment. What are those which are immovable by attachment? They are trees, plants, and growing fruits while they are attached to the land or form an integral part of the immovable. So in other words, they are adhered to the soil. Okay, they cannot be moved because they are attached to the soil, and therefore they become an integral part of the land to which they are attached. Okay, another one is everything attached to an immovable in a fixed manner in such a way that it cannot be separated from the immovable without breaking the material or causing a deterioration of the object. In other words, if that thing is placed on an immovable and that thing is removed from the immovable to which it is attached, the thing which is attached to the immovable becomes broken. It becomes useless. And therefore, considering that it is already useless, it does not satisfy any human want or human needs. So it ceases to be considered as property. So everything which is attached to the immovable in such a manner that if you remove it from the immovable to which they are attached, they become useless. It is an immovable by attachment. Okay? Um, Another kind or classification of an immovable property are as follows: statues, reliefs, paintings, or other objects for use or ornamentation placed in buildings or on lands by the owner of an immovable in such a manner that it reveals the intention to attach them permanently to the tenements. Another is machinery, receptacles, instruments, or implements intended by the owner of the tenement for an industry or works which may be carried on in a building or on a piece of land and which tend directly to meet the needs of the said industry or works. Another one is animal houses, pigeon houses, beehives, fish ponds, or breeding places of similar nature in case their owner has placed them with the intention to have them permanently attached to the land. The animals in these places are included. So what is the common denominator with respect to these immovables? These immovables are movable by nature. Okay? They are not immovable by nature. They are not attached to the land. Okay? But they become immovable because of the intention of the owner. Okay? So with respect to statues, reliefs, and other objects or ornamentation, it has to be placed in the immovable by the owner. So if it is placed by one who has only a temporary right on the immovable, such as a lessee, if for example a lessee has placed a painting, okay, in a house, for example, that was the subject of the lease, that painting was never converted into an immovable by the mere fact that the owner has placed it in the leased property. So it is imperative for this painting or statue or other objects of ornamentation that the person who placed it in the immovable is the owner of the said property. It should be the owner not only of the painting but the immovable to which they are placed. Okay, the same is true with respect to machinery. Okay, it must be placed by the owner of the immovable and it must directly meet the needs of the industry. Okay, industry which is being carried on in the immovable. So if it is a building, for example, which is intended to be a chocolate making factory, okay, the machinery must be placed by the owner of that building, okay, for it to be considered as an immovable. Okay. The same is true with respect to animal houses and other similar breeding places. They must be placed by the owner. If it is only placed by a use of fructuary, it does not become immobilized by the fact that the use of fructuary has placed the said breeding places in the object of the use of fructuary. So it is needed in all of these instances that the owner must be the one who placed the said object of ornamentation, machinery, or breeding places in the immovable to which they are placed. Otherwise, if it is merely placed by one who only has a temporary right, then it does not become immobilized. Okay, is that clear? Another kind of immovable property is an immovable by assimilation. Okay? It is mixed with the immovable in such a way that you can no longer separate it from the immovable because it already formed part of the immovable to which they are mixed. Example is fertilizers. If you mix fertilizers on a piece of land, you can no longer separate the fertilizer from the land on which they are mixed. Okay, another one is mines, quarries, and slab dams, while the matter thereof forms part of the bed and waters either running or stagnant. Okay, so the mines, as long as they are not separated from the soil, they are considered as immovable. But once minerals are already separated or severed from the soil, they cease to be immovables, but they become movables. The same is true with respect to waters. As long as they form part, okay, of the waters which are either running or stagnant, they are considered as immovables. Okay, then we have the other types of immovables, the ducts and structures, which though floating are intended by their nature and object to remain at a fixed place on a river, lake, or coast. Okay, they are immobilized by destination. So they are fixed structures which are intended to remain either at a port or at a river or a coast. Okay? And then the last one is contracts for public works and servitudes and other real rights over immovable property. Class, you must remember that any contract, the subject matter of which is a real right over immovable property, is considered as an immovable property. Okay, again, any contract, the subject matter of which is immovable property, are considered as one of the immovable properties. So, immovable properties do not only consist of tangible objects, they may also consist of rights, real rights over immovable properties. Okay? Now, you may ask, what is the reason? Why is it that we need to know the distinction between movable and immovable properties? Because we need to know the distinction because there are certain implications. Example of which is there are implications on taxation. Okay, you already know that there are real property taxes imposed on immovable properties. So you need to know the distinction for you to be able to know whether a certain kind of property should be assessed of real property taxes. Another implication would be on criminal law. From your criminal law, you know that only personal properties can be the subject of theft because asportation is an essential element of the offense of theft. And if a thing which is not capable of being transported or moved, it cannot be the subject of theft because of the absence of the element of asportation or taking. Okay, on the other hand, real properties for purposes of criminal law, okay, can be the subject of usurpation under Article 312 of the Revised Penal Code. They cannot be the subject of theft precisely because you cannot take or move a real property from one place to another. Okay? So another reason why we have to distinguish between movable and immovable properties is for purposes of remedial law. The remedies that are available for the purpose of recovering a real property is different from the remedy for the purpose of recovering personal property. Okay? With respect to personal property, you file a reclaiming suit. With respect to real properties, you can resort to ejectment, recovery of possession, or reconveyance as the case may be. Okay, we will discuss that further when we go to the remedies for vindicating ownership or possession of real properties. Okay, uh, and the fourth reason why we have to know the distinction between real and personal properties are there are certain implications on legal formalities. Of course, when you are dealing with real property uh, and you are trying to mortgage it, you will have to execute a deed of real estate mortgage. On the other hand, if it is a personal property, it would be a deed of chattel mortgage. Okay, so let us go to jurisprudence as regards what is considered to be an immovable property. In the case of Becerra versus Tenesa, uh, the house was classified as an immovable property by reason of its adherence to the soil on which it is built. The classification holds true regardless of the fact that the house may be situated on land belonging to a different owner. But once the house is demolished, it ceases to exist as such and hence its character as an immovable likewise ceases. Remember, under paragraph 1 of Article 415, lands, buildings, okay, and all other kinds of constructions adhere to the soil as considered as immovable by nature. So it did not impose as an additional requirement that the building must be constructed or built by the owner of the land. Okay, so regardless of who constructed the building or the house, it is considered as immovable by nature. Okay, the authority for this is Visera versus Tenesa. Okay, but again, once the house is already demolished, it becomes personal property. Okay? We also have another case, Tumalad versus Vicencio. Okay. In Tumalad versus Vicencio, the Supreme Court tells us that in this case, there was a chattel mortgage which was executed by the appellants in favor of the appellees over their house of strong materials, okay, in order to secure a loan. However, the appellants was not able to pay the loan, so it was foreclosed extrajudicially and the house was sold at public auction. Remember, the house is unimmovable by nature, but it was subjected to a chattel mortgage and not a real estate mortgage. So the mortgagor or the appellant considered the property as a personal property. The question is, can you, by stipulation, treat a building which is immovable by nature under Article 415 as a personal property? Okay, the Supreme Court said, although there is no specific statement referring to the subject house as personal property, yet by ceding, selling, or transferring a property by way of chattel mortgage, appellants could only have meant to convey the house as a chattel, or at least intended to treat the same as such, so that they should not now be allowed to make an inconsistent stand by claiming otherwise. So the Supreme Court tells us that even if under Article 415, a building is considered as immovable by nature, the parties, by stipulation, can treat the same as a personal property and they are estopped to deny the same. So as long as between themselves they treated a property which is immovable by nature as a personal property, they cannot later on deny and allege that it should be an immovable property and not a personal property pursuant to the equitable doctrine of estoppel. So the parties are estopped from claiming otherwise. Okay? We have Benguet Corporation versus CBAA. It is a 1993 case. Okay, the Benguet Corporation case uh, uh, explains or clarifies again what is meant by lands, buildings, and other constructions adhered to the soil. So Benguet speaks of a tailing dam. It is actually a construction or an improvement, okay, which is adhered to the soil. Okay, it is being subjected to real property tax because according to the assessor, it is an improvement upon the land. Okay, the Solicitor General, on the other hand, argued that the dam is an assessable improvement because it enhances the value and utility of the mine. So the primary function of the dam is to receive, retain, and hold the water coming from the operations of the mine, and it also enables the petitioner to impound water, which is then recycled for use in the plant. So the Supreme Court sustained the contention of the Solicitor General and held that the subject dam falls within the definition of an improvement because it is permanent in character and it enhances both the value and the utility of petitioner's mine. Remember, it is a construction which is adhered to the soil and it enhances the value of the immovable to which it is attached. So it was considered as an immovable by nature pursuant to Article 4151 of the Civil Code. Okay? We now go to the case of Evangelista versus Alto Surety. So in this case, the petitioner filed a case for collection of sum of money against Rivera. They obtained a writ of possession and levied upon a house built by Rivera on a land situated in Manila and leased him. Rivera refused to surrender it on the ground that he had leased the property from Alto Surety. Now, the basic issue in this case is whether a house constructed by the lessee on the land on which it is built should be dealt with for purposes of attachment as immovable property or as personal property. The Supreme Court said that the house is not personal property. It is an immovable property. As explicitly held in one case, a true building not merely superimposed on the soil is immovable or real property, whether it is erected by the owner of the land or by a usufructuary or a lessee. Again, this is a reiteration of the case in Becerra versus Tinesta, that regardless of the person who built on an immovable, okay, as long as it is immovable by nature, such as a building or a construction which is adhered to the soil, it is unimmovable. It need not be erected on the immovable by the owner of the land. Okay. However, this view is good only insofar as the contracting parties are concerned. It is based partly on the principle of estoppel. Okay. So another case is Yi versus strong machinery. Okay, so far, we have learned that the parties can stipulate a property which is immovable by nature, even if it is unimmovable by nature. The parties can still treat it as a personal property or immovable by stipulation. And they are bound because of the principle of estoppel. The contract is the law between the parties. However, if there are third persons which are involved, such third person is not bound by the said stipulation. So, said third person can still insist that the property, insofar as that third person is concerned, is unimmovable and not immovable pursuant to the party stipulation. Okay, that is what the Supreme Court told us in the case of Yi versus strong machinery. So in this case, Agricola bought a rice cleaning machinery from Strong. So the rice cleaning machinery became the subject of a chattel mortgage to secure payment of the loan. So it included in the mortgage deed the building of Strong materials in which the machinery was installed. So the loan was not paid and therefore it was foreclosed. However, Agricola executed another mortgage on the lot uh, upon the building separate and apart from the land on which it stood. So we have two mortgages. The action was instituted by the plaintiff to recover possession of the building from the machinery company. So the building of Strong materials in which the rice cleaning machinery was installed by Agricola was real property. And the mere fact that the parties seem to have dealt with it separate from the land on which it stood in no way changed its character as real property. Why? Because there is a third person which is involved. Remember, Agricola executed two mortgages. One on the machinery and the other on the building separate from the lot on which it's stood. So if there are third persons which are involved, said third persons can insist that it is unimmovable pursuant to Article 415 and not immovable as agreed upon by the parties. Then we have Navarro versus Pineda. Again, Navarro versus Pineda is a reiteration that the parties may agree to consider a house as a personal property, but it is good only insofar as the contracting parties are concerned pursuant to the principle of estoppel. So it is merely a reiteration of the doctrine in Evangelista versus Alto Shuri. We have the case of Soriano versus Galit. Okay, in this case, the writ of possession was nullified by the Court of Appeals because it included a parcel of land which was not among those enumerated in the certificate of sale issued by the sheriff, but on which stand the immovables covered by the said certificate. So the petitioner contended that the sale of these immovables necessarily encompasses the land on which they stand. So the Supreme Court held that considering that what was sold by virtue of the writ of execution was merely the storehouse and the bodega constructed on the parcel of land covered by transfer certificate of title, which by themselves are real properties of respondents, the same should be regarded as separate and distinct from the conveyance of the lot on which they stand. So, immovable by nature or incorporation. Another immovable by nature or incorporation, aside from lands, buildings, and constructions adhered to the soil, are trees, plants, and growing fruits. while they are attached to the land or form an integral part of an immovable. So they're immovable by nature if there was no human intervention in planting the same on the land. Okay, if the trees sprouted from the land and grew without human intervention, they are considered as immovable by nature. Okay, um, they should remain also attached to the land. Once they are severed from the soil, they cease to be real properties, just like a house or a building. Once they are um, removed from the land, once they are demolished, they cease to be considered as an immovable. They become personal properties. The same is true with respect to trees, plants, and growing fruits. Okay. However, with respect to growing fruits or crops, they are considered as a special kind of an immovable because there is that doctrine which is known as mobilization by anticipation. Okay, growing crops, even if uh, they are still adhered to the soil, okay, even if they are standing and are still considered to be adhered to the soil, and even if they are not yet harvested, they can be the subject of a contract of sale. That this is what is known as mobilization by anticipation because it is expected that the crops will be harvested. The authority for that matter is contained in the doctrine in Sibal versus Valdez. Okay, so in this case, the sheriff attached by virtue of a writ of execution sugar cane which were planted by the plaintiff. Now, the basic issue in this case is whether the sugar cane is personal or real property. It is contended that the sugar cane comes under the classification of real property as ungathered products because, as you know, growing crops, growing fruits are considered as adhered to the soil. So the Supreme Court said standing crops and the fruits of trees not gathered and trees before they are cut down are considered as part of the land to which they are attached. But the immovability provided for is only one in abstracto and without reference to rights on or to the crop acquired by others than the owners of the property to which the crop is attached. The existence of a right on the growing crop is a mobilization by anticipation, a gathering as it were in advance, rendering the crops movable. So because you planted the crops with the expectation that it will be harvested. So that's the reason why, even if it is still attached to the land and it is still a growing crop, there is the so-called mobilization by anticipation, as if you were gathering in advance the crops that are still standing. Okay. Growing crops raised by yearly labor and cultivation are considered personal properties. A valid sale may be made of a thing which, though not yet actually in existence, is reasonably certain to come into existence. So he may make a valid sale of the wine that a vineyard is expected to produce. So, for example, the grapes which are still hanging and are not yet harvested. Okay, they can be considered as personal properties through the doctrine of mobilization by anticipation. Or the grain a field may grow in a given time, or the milk a cow may yield during the coming year, or what may be taken at the next cast of a fisherman's net, or young animals not yet in existence. Okay, however, they must be owned at that time by the vendor. So the plants as well as the animals must be owned by the vendor. And also, under the chattel mortgage law or Act 1508, it fully recognized that growing crops are personal property. So by specific provision of law, growing crops are considered as personal property. We also have the so-called immovable by attachment or by incorporation. So this is a catch-all provision saying that everything which is attached to an immovable in a fixed manner in such a way that it cannot be separated without breaking the material or causing the deterioration of the object. Again, this is a catch-all provision. The critical thing that you must determine is whether that thing which is attached to the immovable can be, if it is separated from the immovable, it can become useless because the property becomes damaged if it is severed from the immovable to which it is attached. In such a case, it is an immovable by incorporation or an attachment. So it does not distinguish who placed that thing to the immovable. Okay, what is important is that if it is severed from the immovable, it becomes damaged to the point that it becomes useless. Okay, so examples would be ornamental stones embedded on a statue or embellishments placed on a mural painting or a decoration fountain in a home. In this provision, it is not required that the owner should be the one to incorporate it in the property. It is also not required that it serves the purpose of the business or industry to which the uh, thing was attached. Okay, the only thing that is required is that it is attached. Again, it is attached in such a manner that if you separate it from the immovable to which it is attached, okay, it becomes damaged and it can no longer serve its purpose. We now go to jurisprudence related to this matter. So in this case, in Mies Score versus Central Board of Assessment Appeals, okay, this case involves a pipeline system. Okay, pipeline system from Batangas to Manila. And the pipes are embedded in the soil and are firmly and solidly welded together. Okay, so the provincial assessor of Laguna treated the pipeline as machinery, okay, or improvements. So they are considered by the assessor as real properties, as machineries. Now, can you consider, are the pipelines considered as real properties? The pipeline in question is indubitably a construction adhering to the soil. So it is attached to the land in such a way that it cannot be separated without dismantling the steel pipes which were welded to form the pipeline. So a pipeline for conveying petroleum has been regarded as real property for tax purposes. So it fell under the catch-all provision, which is everything which is attached to an immovable in a fixed manner that it cannot be separated without breaking the material or deteriorate or causing the deterioration of the object. So according to the case of Miesfor, the pipeline cannot be separated without dismantling the steel pipes which were welded to form the pipeline. So it fell under that catch-all provision as an immovable by incorporation or attachment. So it is a proper subject of real property taxes under that catch-all provision of movables through incorporation or attachment. Okay. Again, there are also those immovables which became such because of the intention of the owner. Okay, one of which are statues, reliefs, paintings, or other objects for use or ornamentation placed on buildings or on lands by the owner of the immovable in such a way that it reveals the intention to attach them permanently to the tenements. Remember, these objects of ornamentation have to be placed by the owner of the immovable, owner of the building or owner of the land to which they are placed. Okay, remember, these statues, reliefs, paintings, or objects of ornamentation are essentially movable in nature. But they became immovable because the intention of the owner is to place them permanently on the building or on the land which he owns. Okay, so we have several requirements for the immovable to be placed under this classification. Okay, first, the property must be a statue, relief, painting, or other object for use or ornamentation. Okay, the property must be placed in the building or the land. Okay, the property must be placed by the owner of the immovable. The intention of the owner is to attach the property permanently to the tenement. Examples would be the chairs in a cinema which are bolted, okay, bolted on the floor, the mural paintings, and decorative garden statues. If the said properties were placed by a person who only has a temporary right on the building or the land, said properties will not be considered as an immovable and the same would remain as personal property. Okay? And also, even if it is placed by the owner, if his intention is not to place them permanently, but only temporarily on the premises, then the property will be considered as personal property. Example of which is a painting. If a painting was placed by the owner of the building, but only temporarily, only for the purpose of, for example, there is a certain occasion, okay, which requires the placement of the painting on the wall, okay, and then after the occasion, that painting will be removed and will be returned to its original place. Then that painting cannot be considered as an immovable under this particular provision. Okay, another immovable, which is deemed as such because of the intention of the owner, are machineries, receptacles, instruments, or implements intended by the owner of the tenement for an industry or works, which is carried on in the building or on land, and which tend to directly meet the needs of said industry or works. There are two important requirements for this provision to apply. First is that it must be placed by the owner. Okay. Second is that it must directly meet the needs of the said industry or works. Okay. What are the requirements again? The property that is involved is machinery or other instruments intended for an industry or work. Okay, the property must be placed by the owner or his agent and not a mere lessee or usufructuary. So one should not be the one who placed the same must not be holding the said property on a temporary basis. Like for example, a lessee or a usufructuary. So if it is placed by a lessee or a usufructuary, that machinery remain to be personal property. It is not converted into a real property. Okay, the industry or work must be conducted in the building or piece of land, and the purpose of the owner is to use the same to directly meet the needs of the said industry or work. An example would be a machinery which is placed by a bottling company or the car lifter in a car wash, for example. The washing machines in a laundry shop. These are examples of machineries. If they meet the requirements previously mentioned, they become immovable property, even if essentially they are considered as movables. Okay? There is no necessity that it should be incorporated permanently to the building or the land. So there is no necessity of attachment, or you should attach the machinery in such a way that if you if you sever it from the immovable, it becomes damaged. There is no necessity for that. What is important is the intention of the owner, and what is important is that it directly meets the needs of the said industry. Okay, they're essentially movables, but because of the use that they provide to the industry, they partake of the nature of immovables. Okay, so we go now to cases which illustrates these specific provisions of immovables. So in the case of Meralco versus City Assessor of Laguna, okay, what is involved? The property that is involved in this case are transformers, electric posts, transmission lines, insulators, and electric meters. Now, would these properties qualify as machinery and therefore are considered as real properties subject to real property taxes? So the Supreme Court said, machinery to be deemed real property subject to real property tax need no longer be annexed to the land or building, as these may or may not be attached permanently or temporarily to the real property. And in fact, such machinery may even be mobile. Okay, again, it is a reiteration of what I previously said, that the crucial requirements for a machinery to be considered as an immovable property is the requirement that it must be placed by the owner, okay, of the immovable, of the land or building, and second, that it tends to directly meet the needs of the said industry or work. So it need not be attached to the building or to the land in such a manner that you cannot separate it without damaging the machinery. That is not one of the requirements for a machinery to be considered as an immovable. In fact, according to Meralco versus City Assessor of Laguna, the machinery may even be mobile. Okay? Uh, the properties under Article 415, Paragraph 5 of the Civil Code are immovables by destination, or those which are essentially movables, but by the purpose for which they have been placed, partake of the nature of the latter because of the added utility which is derived therefrom. Okay, another case illustrating this provision on immovables is Capital Wireless versus Provincial Treasurer of Batangas. So what is involved in this case are submarine communication cables. So these are the cables which are submerged deep into the sea. Okay, they were assessed real property taxes. Now, can you consider this submarine communication cables as real properties? So the court ruled in the affirmative. The court said it sees no reason to distinguish between submarine cables used for communications and aerial or underground wireless or lines used for electric transmission, so that both pieces of property do not merit any different treatment with respect to real property taxation. Both electric lines and communication cables are not directly adhered to the soil but pass through post relays or landing stations. But both may be classified under the term machinery as real property. So such pieces of equipment serve the owner's business or tend to meet the needs of his industry or works that are on real estate. So further, Capital Wireless further told us that a classic example is a boathouse, which by its nature is a vessel and therefore a personal property. But if it is tied to the shore and used as a residence, and since it floats on waters, which is immovable, is considered as real property. So both the case of Capital Wireless and Meralco tells us that uh, these properties are essentially movables. However, the machineries, as long as they are placed by the owner of the immovable to meet directly the needs of the business which is carried out in the said immovable, okay, they are considered as immovable properties even if they can be essentially mobile. What is important is the utility that is being provided by these machineries to the immovable to which they are placed. Okay? We also have the case of surge products versus PCI. So in this case, PCI filed a complaint for collection of sum of money with application for writ of replevin. So the sheriff seized one machinery. Okay, the motion was opposed by PCI on the ground that the properties were personal and therefore still subject to seizure and writ of replevin. The petitioners asserted, on the other hand, that the properties were immovable. So the contracting parties, again, as we have learned earlier, the contracting parties may validly stipulate that although the property is considered as immovable, they can stipulate or agree that it is a personal property. And after agreeing to the said stipulation, they are bound by estoppel from claiming otherwise. So in this case, the lease agreement clearly provides that the machines in question are to be considered as personal properties. Clearly then, petitioners were estopped from denying the characterization of the subject machines as personal property. However, it is good only insofar as the contracting parties are concerned. So the chocolate making machinery in this case of search products, even if they are considered as real properties under Article 415, the parties stipulated that it is a personal properties. The machineries are personal properties and they are bound by the said stipulation pursuant to the equitable doctrine of estoppel insofar as the contracting parties are concerned. Okay? We have another case, Chai versus Court of Appeals. Okay, in this case, Evertex secured two loans from PBCom. As security for the first loan, Evertex executed a deed of real and chattel mortgage over the lot where its factory stands. So Evertex filed a complaint for annulment of sale, reconveyance, and damages against PBCom, alleging that the extrajudicial foreclosure of the mortgage was void because it appropriated the contested properties which were not included in the real and chattel mortgages. While it was true that the controverted properties appeared to be immobile, a perusal of the contract executed by the parties state that they intended to treat the machinery and equipment as chattels. So the court previously ruled that an immovable may be considered as personal property if there is a stipulation as when it is used as security in payment of an obligation where a chattel mortgage is executed over it. So it is a reiteration again of the doctrine in search products. So Chai versus Court of Appeals. So inasmuch as the subject mortgages were intended by the parties to involve chattels, insofar as the equipment and machinery were concerned, the chattel mortgage law applies. Remember that machineries are considered if they are placed by the owner and they are intended to meet directly the needs of the industry in which they are placed, they are considered as immovables. However, it became the subject of a chattel mortgage. And as you know, chattel mortgages cover only personal properties. So the parties treated the machineries as personal properties, and they are bound by the said contract, and they cannot deny and later on allege that the said properties are immovable property. Okay? Davao Sawmill versus Castillo. A Davao Sawmill is the holder of a lumber concession from the government. However, the land upon which the business was conducted belonged to another person. So the sawmill company erected a building which housed the machinery used by it. It was agreed that upon the expiration of the lease, all the improvements shall be owned by the lessor. So Davao Sawmill is the owner of the machinery, and he placed the machinery upon the land which is owned by another person because it was only leasing the land. So Davao Sawmill has on a number of occasions treated the machinery as personal property by executing chattel mortgage in favor of third persons. So machinery, which is movable by nature, only becomes immobilized when placed in a plant by the owner of the property or plant, but not so when placed by a tenant, usufructuary, or any person having only a temporary right, unless such person acted as the agent of the owner. So that is the important doctrine in Davao Sawmill versus Castillo. Okay, machinery becomes immobilized only if placed by the owner of the immovable to which they are placed. Okay, so if it is placed by a person who only has a temporary right on the tenement, that machinery does not become immobilized. Okay, it becomes immobilized only when it is placed by the owner of the tenement. Okay, another case, we have Makati Leasing versus Wherever. To secure the collection of the receivables assigned, private respondent executed a chattel mortgage over certain raw materials inventory as well as machinery. So the property involved here is a machinery which became the subject of a chattel mortgage. So upon default, the sheriff removed the main drive motor of the subject machinery. So the machinery in suit cannot be the subject of a replevin, much less of a chattel mortgage because it is a real property. So the issue in this case is whether the machinery is real or personal property from the point of view of the parties, with petitioner arguing that it is a personal property while the respondent is claiming that it is real property. So if a house of strong materials like what was involved in Tumalat may be considered as personal property for purposes of executing a chattel mortgage, as long as the parties to the contract agree and no innocent third parties will be prejudiced. There is absolutely no reason why a machinery which is movable in nature and becomes immobilized only by destination or purpose may not likewise be treated as such. This is really because one was so agreed is estopped from denying the existence of the chattel mortgage. So again, it is a reiteration of the previous rulings of the court relative to the parties treating an immovable property as a personal property by the stipulation in their contract. Okay. Another important case with respect to machineries is Mindanao bus versus city assessor. Mindanao bus versus city assessor. Okay, in this case, uh, petitioner Mindanao Bus is engaged in the transportation of passengers and cargoes. Now, the assessors sought to assess the machinery sitting on a cement and wooden platform in their repair shop. So they have repair shops, Mindanao Bus. Now, in that repair shops, there are machineries. Now, the assessor is assessing the machineries in their repair shop. On the other hand, Mindanao Bus contended that the said equipments are immobilized by destination. Okay, so the question here is, are the machineries inside the repair shops of Mindanao Bus considered as uh, immovables and therefore are subject to real property taxes? Okay, so that movable equipments be immobilized in contemplation of the law, they must first be essential and principal elements of an industry or works, without which such industry or works would be unable to function or carry on the industrial purposes for which it was established. Okay, in this case, those which may not be so considered immobilized because they are merely incidental, not essential and principal. Thus, cash registers, typewriters, usually found in hotels, restaurants, theaters are merely incidentals and are not and should not be considered immobilized by destination. For these businesses can continue or carry on their functions without these equipments. Airline companies use forklifts, cheap wagons, pressure pumps, machines which are incidentals, not essentials, and thus retain their movable nature. On the other hand, machineries of breweries used in the manufacture of liquor and soft drinks, though movable in nature, are immobilized because they are essential to the said industry. But the delivery trucks and adding machines, which they usually use and are found within their industrial compounds, are merely incidentals and retain their movable nature. So the tools and equipments in question are by their nature not essential and principal elements of petitioner's business of transporting passengers and cargoes by motor trucks. They are merely incidentals acquired as movables and used only for expediency to facilitate or improve its service. The transportation business could be carried on without the repair or service shop if or its rolling equipment is repaired or serviced in another shop belonging to another. Therefore, the said equipments may not be deemed real properties. So what is important in the case of Mindanao Bus is the definition of the phrase which tend to directly meet the needs of the said business or industry. So in order for the machinery to be considered as directly meeting the needs of the business or industry, they must be the essential and principal elements of an industry or work and not merely incidental. So if it is merely incidental, they remain to be movable properties. They remain to be personal properties. They are not immobilized if they are not essential and principal elements of the business or industry. Okay, that is what is important in the case of Mindanao Bus. Okay, we now move on to the other types of immovables. Okay, and these are the breeding places of animals: pigeon houses, beehives, fish ponds, and other breeding places. Okay, the animals are also included if they are inside these breeding places. Okay. What are the requirements for this provision to apply? First, the property in question must be an animal house, a pigeon house, a beehive, fish pond, or similar breeding places. The one who constructed the breeding place rather, was the owner of the land. So the owner intends to permanently attach the breeding place to the land, and the animals in these breeding places are also considered as real property. Again, it is needed that the one who placed the breeding place must be the owner of the land. If it is one who only has a temporary right on the land, such as a lessee or a usufructuary, again, these breeding places and the animals therein will remain as personal properties. They are not converted to real property. It must be noted, however, that since the animals move from place to place, the animals are still considered as personal property for purposes of criminal law. Okay? So if, for example, the animal is still in the breeding place, such as a pigeon, and the pigeon was stolen while the pigeon is still inside the pigeon house, that will still be considered as theft, even if under Article 415, the animal inside the pigeon house is deemed as real property. Because for purposes of criminal law, these animals, insofar as criminal law is concerned, are considered as personal properties. Okay? Also, fertilizers, when they were actually used in a piece of land, okay, are mixed with the land itself. Therefore, it is not possible for you to remove and identify the fertilizer as opposed to the soil. They become part of the land and therefore are considered as immovable. But fertilizers, if they are still in the sacks, are not considered as real properties. They remain to be personal properties. Okay, now what are the other real properties? Mines, quarries, and slug dumps, while the matter thereof forms part of the bed and waters either running or stagnant. You must remember that to be considered as real property, the minerals, quarries, and slag must still form part of the bed. However, when it is separated from the soil, it is no longer real property, but it becomes personal property. Remember that if the minerals are taken from the soil, they cease to be real properties. They become personal properties. Okay, what are slag dumps? When the iron ore rock melts in a furnace, the impurities separate from the iron and turn into a molten rock called slag. Now, the mills used to ship this slag off in insulated slag train cars to be dumped off the side of cliffs into one of the many slag dumps. When we speak of waters in this provision, they refer to those which are already appropriated and not to those large bodies of water which are not capable of appropriation. Remember the waters in the ocean, as I told you earlier, they are not susceptible of exclusivity and therefore they are not qualified to be considered as property. Okay, the docks and structures are immobilized by destination because they are intended to remain at a fixed place. Okay, boats, yachts, for example, that are docked and used as residences are considered as real property. Okay, we now go to the last slide. Not all real properties are tangible, meaning that they can be felt with the five senses. There are certain real properties which are intangible, okay, meaning you cannot feel it or you cannot sense it. but they exist. Okay, example of which are contracts for public works. So the contracts with the DPWH and other government contracts involving public works are considered as real property. Easements and servitudes. So easements of right of way and servitude contracts are considered as real property. Other real rights over immovable property. So contract of lease, for example, a contract of lease is a real or an immovable property. So all agreements, the subject matter of which is real property, are considered as immovable property. Example, a deed of sale of a real property, it is an immovable property. A contract of lease over real property, that is a real property. A contract of use of rock, that is a real property. Okay, so that's about it. We have covered immovables. We now go to movable properties. Okay, we now come to movable properties. Again, the Civil Code did not provide for any specific definition of what is a movable property. However, it correlated the definition of movable property to the enumeration of immovable properties under Article 415. Okay, so Article 416 defined movable properties also through enumeration as follows. Those movables susceptible of appropriation which are not included in the preceding title. So as I have mentioned a while ago, we have to consult Article 415 to check if the property subject matter if the property is included in Article 415. If it is not, then it is a movable or a personal property. Okay, real property which by any special provision of law is considered as a personal property. Previously, when we were discussing immovable properties, we said that by the provision of Act number 1508 or the Chattel Mortgage Law, growing crops, even if they are considered as an immovable property under Article 415, paragraph 2, the same is considered as a real property, as a personal property rather, by special provision of the law. So that is a classic example of a real property which by special provision of the law is considered as a personal property. Number 3, we have forces of nature which are brought under the control of science. So electricity, for example, or Wi-Fi signal, for example, or internet connectivity, for example, is a force of nature which is brought under the control of science and which is considered by law also as a personal property. The number 4 in the enumeration is what is traditionally considered as movable property. All things which can be transported from place to place without impairment of the real property to which they are fixed. So in general, if you can transport or if you can move the property from one place to another, that is a movable property. Okay, so is it are movable properties always tangible? Are they always tangible properties? The answer is no, because under Article 417, the intangible properties subject of this provision are considered as movable property, such as obligations and actions which have for their object movables or demandable sums. Example, in a contract of loan, okay, the right to collect money pursuant to a loan agreement is considered as a movable property. Distinguish this from our previous discussion on immovable property. Any contract, if the subject matter of which is a real property, is considered likewise as an immovable property. So in the same manner, if the subject matter of the contract is a movable property, the same may be considered as a movable property. Another one are shares of stocks in agricultural, commercial, and industrial entities, although they may have real estate. So a share of stock is considered as a movable property. So another classification or distinction of movable properties is provided under Article 418. Okay, according to Article 418, movable properties may either be consumable or non-consumable. So to the first class belong those movables which cannot be used in a manner appropriate to their nature without them being consumed. So if you use the thing, then it is consumed and therefore it disappears. Okay, to the second class belong all the others. So non-consumable properties, it is not destroyed by use. It is not destroyed by appropriation. You still have the property. So again, to repeat, movable properties, again, akin to immovable properties are not defined by the Civil Code. Instead, movable properties are also defined by enumeration. So movable properties may either be tangible, can be felt by the senses, or intangible, such as rights and obligations and shares of stocks. It can also be consumable, meaning through its use, it disappears, or non-consumable, that it is still existing even if it is appropriated. Okay. Now, what are the tests to determine the classification of property? Again, if the property is not included in the list of immovable properties under Article 415, it is considered as a movable property. So you have to consult Article 415 and see if it is within the enumeration. If it is within the enumeration, then that is not a movable property. But if it is outside or is not included in the enumeration, then it definitely falls as personal property. Example of which would be cars, computers, and jewelry. Okay? Another test to determine if the property is a personal property is its nature. Can it be moved from one place to another without injuring the immovable to which they are attached? If it is, then the property is considered as a movable, of course, subject to certain exceptions, such as machineries, which are placed by the owner to directly meet the needs of the business or industry, or statues or paintings, which are placed by the owner. So again, you will have to consult Article 415 if the property, which is essentially a movable, can be considered as an immovable. Okay, if it does not fall within 415, then it is definitely under 416. Okay, the third one is you consult the law. Is there a specific law which classifies the property as a personal property. If there is such as growing crops, which under Article 1508, Section 7 of the Chattel Mortgage Law is considered as a personal property, then it is a personal property, even if the Civil Code under Article 4152 provides that growing fruits are considered, if it is still adhered to the soil, is still considered as real property. Okay? Since a specific law is provided on the matter, then that specific law will prevail over the civil code, which is a general law. Now, as I have said a while ago, movable properties are not only tangible. There are the so-called intangible real properties, okay, such as rights, which have for their object movable properties. Okay, the kinds of intangible immovable properties are obligations and actions which have for their objects movables or demandable sums. Example of which is an action for collection of sum of money, shares of stocks, and other intangible personal property such as trademarks, patents, and copyrights. However, it must be noted that not all personal properties may be the subject of theft. Only tangible personal properties capable of being taken physically may be the subject of theft, as we have discussed a while ago. So the provision of services or interest in a business are intangible personal properties not capable of being physically taken, and thus they cannot be the subject of theft, as we will learn later in the following cases. Okay, US versus Carlos. As we have discussed a while ago, forces of nature which are brought under the control of science are one of those which are considered as movable or personal properties. So in this case, what was discussed was electricity. Can electricity be the proper subject of theft? Remember that to be the proper subject of theft, the subject of the offense must be a personal property. You cannot have theft or larceny over immovable properties. It can be subject of usurpation under Article 312 of the Revised Penal Code, but it cannot be the subject of theft. So in this case, the Supreme Court held that electricity is regarded by electricians as fluid, but its manifestations and effects, like those of gas, may be seen and felt. The true test of what is a proper subject of larceny seems to be not whether the subject is corporeal or incorporeal, but whether it is capable of appropriation by a person other than the owner. So, the for theft, one of the elements of theft is taking or asportation. So, can electricity be considered as a proper subject of theft, even if you cannot touch it or you cannot bring it from one place to another? So in this case, in US versus Carlos, as early as US versus Carlos, which is a 1911 case, the Supreme Court said yes, because it is not whether the subject is corporeal or incorporeal, but whether it is capable of being appropriated by someone other than the owner. Electricity, the same as gas, is a valuable merchandise, bought and sold like other personal properties, and is capable of appropriation by another. So no error was committed by the trial court in holding that electricity is a subject of larceny. Okay? Okay, so let's go to another case. How about the business of providing telecommunication services? Can it be the proper subject of theft? because in U.S. versus Carlos, the Supreme Court held that what is important is that the property can be appropriated by someone other than the owner. So in that case, electricity was held to be the proper subject of theft. Now, can the business of providing telecommunication services be considered as a proper subject of theft? We have the case of Laurel versus Abdogar. So in this case, Baynet, okay, has provided a scheme by which he availed of the services of PLDT. And then through um, using a system, okay, he used the system of PLDT to make it appear that international calls are converted into long distance calls only, domestic long distance calls. So they were able to provide a lower rate to their customers to the prejudice of PLDT. So what PLDT did was it filed an information for theft against Baynet. PLDT contended that the petitioner, on the other hand, contended that international long-distance calls are not personal property. They are not capable of appropriation. He maintained that the business is not considered as personal property. In other words, the business of providing telecommunication services is not considered as a personal property. So the question is whether or not international telephone calls using base super orient cards through the telecommunication services provided by PLDT, uh, whether or not PLDT's business of providing telecommunication services are proper subjects of theft. You must remember that for simple theft to be present, the concurrence of the following elements are necessary. First is the taking of personal property. Second is that the property belongs to another person. Third is that the taking should be done with intent to gain, and that the taking be accomplished without the use of violence or intimidation of persons or force upon things. In this case, personal property under the penal code must be considered in relation to the word take. So the statutory definition of movable property indicates that not all personal properties are proper subjects of theft. The general rule is that only movable properties whose physical and or material existence and are susceptible of occupation can be the proper objects of theft. So a naked right, existing merely in contemplation of law, although it may be very valuable to the person who is entitled to exercise it, is not the subject of theft or larceny. Such rights or interests are intangible and cannot be taken by another. Thus, the right to produce oil, goodwill, or an interest in business, or the right to engage in business, credit, or franchise are properties. So is the credit line represented by a credit card. However, they are not proper subjects of theft because they are without form or substance. So we agree, the Supreme Court agreed with the contention of Baynet that intangible properties such as electrical energy and gas are proper subjects of theft. That is a reiteration of US versus Carlos. Gas and electrical energy may be taken, carried away, and appropriated. It is a valuable article of merchandise bought and sold like other personal property, susceptible of being severed from a mass or larger quantity and of being transported from place to place. However, business like services in business, although our properties are not capable of being the object of theft because the same cannot be occupied. If it were otherwise, there would be no difference between the taking of the business of a person or the services, the taking of goods, wares, or merchandise or equipment of a business. So in this case, respondent PLDT does not acquire possession, much less ownership of the voices of the telephone callers or of the electronic voice signals or current emanating from the said calls. So the human voice and the electronic voice signals are intangible and not susceptible of possession, occupation, or appropriation by PLDT or even the petitioner. For that matter, PLDT merely transmits the electronic voice signals to its facilities and equipment. Even at common law, neither time nor services may be taken and occupied or appropriated. Service is generally not considered property, and a theft or service would not therefore constitute theft since there can be no asportation. Okay, under Article 418, again, it provided a subclassification of movable properties into consumable properties or those which disappears whenever it is used. Example of which are food, bread, mobile load, or money. Non-consumable, those which still retain their existence even when used. Example would be laptops, ballpen, and clothes. Movables may also be classified according to the intention or purpose of the parties as follows. They may be classified as fungible if they can be replaced with the same kind, quality, and quantity. Example would be rice, okay? A sack of rice, okay? One example, R160 rice may be replaced by another sack of R160 rice. In the same manner, a non-fungible property is if the parties intended that exactly the same property would be returned and that the same cannot be replaced by another property. Example would be the Mona Lisa painting, the original one, the authentic one. Okay, if it cannot be replaced by another property. Even if you copy it, it is still not replaceable by another property. Okay, so that's it for movable property. Thank you for listening, and I hope that I have contributed to your knowledge.